Welcome to the afternoon session of the House Government Operation and Military Affairs Committee. We are here this afternoon. We're going to be hearing a couple of brief bill introductions of bills that have been introduced in our committee. And we have the sponsor of H97, Representative Robin Scheid here. So Robin, tell us about H97.
Thank you. So for the record, Robin Scheid from Middlebury. Nice to see you all and thank you for having me. I always have laughed in my time here when somebody comes and starts off by saying it's a simple bill. So I'm not going to say that. I'm going to say it's a very narrowly focused bill.
Oh, I like that. Good work.
Okay. I practiced. So my bill, H97, proposes one thing, and it's related to candidates for election. And what it says is that a candidate who wants to become a write-in candidate needs to get the same number of write-in votes as if they had had a petition. So all of us are representatives, and we had to get 50 signatures. If you want to be a write-in candidate in the primary, you only need to get 25 votes to become a viable candidate on the ballot for the general election. So it's half. And I see this as a fairness issue. I think that write-in candidates should have to get the same number of signatures as those people who who planned ahead and worked and decided to run for office and got their signatures. That's my bill.
Shoot, I was simple.
Very narrow focus.
And this is about the threshold on the primary ballot. This
Yes.
is only about write-in thresholds on the primary ballot.
Yes.
I understand it.
Yes.
We're going to be delving into some elections conversation tomorrow and into some proposed bill language that we're furiously working on. And I like this idea in the context of that. So
Yeah, so I knew that you might be doing some election things. And so if you end up folding this into a larger bill, I certainly personally have no problem with that. I just want to get this done, however it works.
Representative Hooper.
Maybe I read a different something. Was there also a component that said if you were the only individual running or something like that, that the threshold didn't go up as high?
I don't have the bill in front of me. I'm sorry.
No.
I don't recall. Does somebody have more on that than I'm saying? Oh, here we go. Thank you.
There was a thing that I remember reading had an exemption for.
Oh yeah,
Yes.
so this is the second half of section 1A. Candidate's office on primary, except that if a write-in candidate receives more votes than any other candidate whose name is printed on the ballot, the write-in candidate.
Oh, yes. But whose name is printed on the ballot. So you could have put your name, like on your 50 signatures, and your name is printed on the ballot. And in theory, I guess you could get 12 votes, and the write-in candidate could get more votes than you.
And get elected.
And get elected.
Yeah.
And that makes sense. I mean, that's a reasonable thing to do, so. Okay. That's the bill.
Representative Nugent. Questions for Representative Scheid?
I'm just wondering if you know the history or anything behind the number, the 25.
25? That's a great question, and the answer is no. I don't know what the history is. I'm sure that there's somebody in our legislative council who would probably know that.
Tomorrow morning, we are going to have the director of the elections division in, and I think that Mr. Senning would be very happy to talk with you about that. We should remember to ask him that question. Right.
And then I'll watch on YouTube later. The answer is.
The population of the state was 30.
Yeah.
I was excited about having an elections bill being introduced, and one of the first ones that was referred to our committee because there are a number of things that the Secretary of State's office is suggesting, and a couple of things that have come from other legislators that I'm hoping we'll work on in a committee bill that are about these very kinds of things. Or why do we have these specific thresholds? I think there are a lot of questions that we get from constituents all the time about those kinds of things. But this specifically was about making sure there's a threshold. If you're going to be the primary winner, you at least need to get enough enough votes as you would have gotten signatures.
Right, exactly. And I thought about adding other things to this bill because I do have, personal issues with you run in one party and you lose the primary, and so you run in the general under another party. And I decided rather than just take on the world, I would take on one thing and keep it narrow and hope that maybe this committee will look at. I will look forward to hearing.
Any other questions about H97 from the committee? Well, thank you very much.
Okay, thank you. Nice to see you all. We're in the pavilion this week, so it's really fun to see actual legislators.
Oh, so you're not.
You are on an island.
We'll be back next week, so we'll look forward to seeing you then.
Careful what you're.
Let us know when the baby comes.
I will. Yes, thank you. Not mine, my daughter's.
Good job.
Thanks. Good luck to you. Who's next?
The next on our list is Representative Kurt Taylor, so please feel free to take the hot seat. And Representative Taylor.
Appropriations.
Oh, okay. I was like, come on. I didn't realize we're going to black comedy.
We're punchy, yeah, physical content here. I like it. This is a very fun committee, and I appreciate it laying that.
There is not another one that's more fun.
Laying it on. Just
That's a true fact.
The hardworking, humble, and fun House Appropriations, House Government Operations. So, H46, Representative Taylor, please tell us a little bit about H46.
Okay, for the record, Representative Kurt Taylor from Colchester, CHI-20. This is a really complicated bill. I mean, it's probably 100 pages, but it's on your website. It's actually one page. And my testimony is on your website. Also, a couple other documents that might help if you're looking into this more deeply. Basically, I'm going to read my testimony or go through it, the same that's on your website. So I thank the committee, Government Operations and Military Affairs, for this opportunity to provide testimony on H46. And I also appreciate you taking this up so quickly in the biennium. It enables me and also Representative Seth Chase, who is from Colchester, to get this done and move things along for our select board. The purpose of H46 is to validate the dissolution of Colchester Fire District Number 3. This is part of Colchester Select Board's plan to consolidate the provision of fire protection and drinking water services. At one time, there was 5 different water companies providing water to Colchester. And a pipe main would break and someone would call the town, and the town had nothing to do with the water. It was all these municipalities within the town of Colchester. So finally, the select board did decide to consolidate, and this is part of that consolidation process. Okay, because Colchester Fire District 3 is recognized as a municipality, its political and corporate dissolution requires validation by the state. Last session, there was a similar bill for Colchester Fire District Number 1, and it was also similarly validated, that dissolution. So first of all, fire protection service. It's always a little bit complicated or confusing to refer to these fire districts and then say water supply. But in July of 2023, CFD number 3, Colchester Fire District number 3, paid off its fire related debts and liabilities with funds previously provided to the town of Colchester. They were providing water to the town of Colchester under contract. They were paid. They submitted a budget. They were the water people who supplied the water. And also fire district, and they also supplied the fire protection. And they transferred all the fire protection services. So they're getting rid of the fire protection services part of Colchester Fire District number 3. And this was done in July of 2020. Colchester Fire District 3 stopped providing any fire protection services at that time and has not been providing any since. So the fire district side is done. There's the drinking water side. In March of 2022, the residents of Colchester Fire District 3 voted 128 to 115 to dissolve the fire district and transfer all remaining assets and liabilities to Champlain Water District, which was the larger company that's been actually providing the water. They sell it to Colchester Fire District 3. Colchester Fire District 3 sells it to the customers, bills them and things like that. Champlain Water District just provided the water in bulk. They also did the maintenance and repair of the infrastructure. They were under contract by the fire district to provide that. In June of 2022, Champlain Water District executed a purchase agreement with Colchester Fire District 3. Colchester Fire District 3 voters had already said, yes, let's get rid of it. And now in June, they're actually putting up the agreement, the asset purchase agreement, and executed it. The property included all water system piping and infrastructure, hydrants, valves, meters, a small office building, cash, and deposits. The liabilities included 3 existing bond bank loans. Right now, on July 1st of 2022, the asset transfer became effective. Colchester Water District, Champlain Water District has owned and operated the water side and the water system since that date. The current Champlain Water District General Manager Joseph Duncan affirms that as of July of 2022, all necessary transfers have taken place. And there's a document on your website that's his stating that. The residents of Colchester Fire District 3 now receive fire and rescue services from the town of Colchester. Water services are provided by Champlain Water District. H46, the bill, completes this process with the state validating the dissolution of Colchester Water District Number 3 as an operational corporate and political entity. And that's the bill. All it does is validate the dissolution. And I thank you. And any questions?
Representative Higley, Representative Moyer.
Thank you. Thank you, Representative Taylor. Just a question. Any reason why that vote was so close?
I was going to ask the same question.
Yeah, yes. There's a lot of history with volunteer fire districts. They have a lot of, people are emotionally involved with the volunteer fire districts. You know, people get together, they fight fires, they have this organization. They are also, it's an important part of the community. And I think a lot of people really didn't like to see it go. They liked the idea of a volunteer fire district. Unfortunately, the Prudential Committee, the people who run the fire district, said, we can't do it anymore. We're getting old. Nobody's volunteering to come and take our place. This business model doesn't work. We need to, and Colchester Fire District 1 had decided to go that way, and they looked at it and said, this looks like a good move. Now, that the people who have to vote on it still want to hold on. A lot of them still want to hold on to that volunteer fire district, but it doesn't make sense economically. So that was the grind. At the end, a lot of people just voted against it because they would like to see a volunteer fire district.
Yeah.
There was a recount. And it was, yeah, I think it wasn't called for a recount, but it was in the threshold and it was close enough that the town clerk said, let's practice our recounts. And they did a recount.
Thanks.
That's all my questions.
Great. Representative.
This is simply an instance where you are representing the popular interests of your constituents and we need to give you permission to carry that out. Yeah, we need to participate in the legislative action that, right? Is that what the?
So
Yeah.
this is a better question maybe for Tucker about the jurisdiction. So maybe a better way to rephrase the question, if I may,
Hit me.
Might be that This is essentially similar to a charter change where we are able to establish, modify, or dissolve, or, destroy, as Tucker had told us in his testimony on one of our first days, municipal corporations. That's part of our charge here in the legislature and specifically in the Gov.Ops committee. So this is an instance where your voters voted to dissolve or destroy this municipality. It was a relatively close vote, though. I think it was the sense.
Yeah, it's the select board wants to consolidate. The water district wants to go along with that. They had the vote. The people who reside in the water district agreed. And now I just present the bill that's able to do that, to finally get rid of the municipality.
Any other questions for Representative Taylor?
Are we actually merging or are we eliminating? And if we're eliminating, then
We're eliminating, we're dissolving.
okay.
So if I understand your testimony correctly, Representative Taylor, all of the assets and responsibilities that remained with the fire district are already part of the Champlain Water District's.
Correct, yes.
So it's just, it's already been absorbed, and now that we're just being asked to formally remove the.
Since June of last year, they've been providing, I live in the water district, and I've been getting my bills from Champlain Water District instead of Fire District 3.
Well, I think, I know, this seems relatively straightforward. So my commitment to Representative Taylor was that we would take a little bit of testimony in the next couple of weeks from some of the locals or administrators who are involved, just so we understand the context before we move forward. But we'll do a walkthrough with Legislative Council to get their formal take on the language and take this up again in the next couple of weeks and move it forward.
Sounds good.
Thanks for coming down to GOMA today, and
Maybe we'll see some of you in Ways and Means.
I've already been there. I already got a trip up to Ways and Means. Great. Okay. We are moving a little ahead of schedule here, and I'm thankful through the efforts of our fantastic committee assistant that Ori Yang, who is the executive director for the Vermont Human Rights Commission, is here to introduce us to the Human Rights Commission and their work. And I really, really appreciate you coming, and we're doing our introductory phase of having this new committee. So if it would help you, if you want to introduce yourself, and then we might go around and introduce the new House Gov.Ops committee, if that makes sense.
Yes, absolutely. And thank you so much for the invitation. I am so grateful to be here. So my name is Bor, and I am the Executive Director and Legal Counsel of the Vermont Human Rights Commission. And I'd love to tell you a little bit more about what we do and our legislative priorities and answer all your questions as well. But I would really love to meet you all.
How are you? We've met each other over the years in previous committee. Matt Byron, Addison 3, live in Virgins, Vice Chair of Gov.Ops.
I am Lucy Boyden. I live in Cambridge and represent District 103, which is Cambridge and Waterville.
Hi, Representative Lisa Hango, Franklin 5.
Representative Michael Morgan, represent Grand Isle County and western corner of Milton. So 6 towns total.
Bob Hooper, North End of Burlington.
Hi, Mike Morwicki. I'm trying to find out where the camera is so you can see.
In the middle. Always in the middle.
So, hi, Bor. I'm Mike Morwicki from the Wyndham 4 District down in Wyndham County.
Seth Chase, Colchester.
I'm Shay Waters Evans from Charlotte and Heinsberg.
Jay Hooper, Brookfield, Braintree, Randolph, Granville, and Roxbury.
Kate Newton, a portion of South Burlington, Chittenden 10.
Mark Higley from Orleans Memorial District.
And we've met many times in the last couple of years, at least virtually. But Mike McCarthy, St. Albans, and very happy to have you with us and to learn a little bit more about the Human Rights Commission's work.
Yeah, so nice to meet some new faces and also see familiar ones, although maybe in different committees. So that's interesting. So the Human Rights Commission was created by the legislature more than 30 years ago. And it was designed to enforce the anti-discrimination laws in the state of Vermont. And the three primary areas are the Fair Employment Practices Act, which is all of employment discrimination. The Attorney General's office investigates employment discrimination cases when the employer is a private employer or a municipality. But the Human Rights Commission investigates when the employer is a state agency or department. And so for the 8,000 plus employees that work for the state, if they experience any form of discrimination, they would come to the Human Rights Commission, not the Attorney General's office. The Human Rights Commission is the only agency that enforces the Public Accommodations Act and the Fair Housing Act. So any kind of discrimination that people experience in housing, either through landlord or neighbor-on-neighbor harassment, or a real estate agent or broker or a lender or a zoning board that makes a housing decision that is discrimination, would also come to the Human Rights Commission, and places of public accommodations. In Vermont, we enjoy a very broad definition of places of public accommodations. Like other states, places of public accommodations includes stores, like the Walmarts, as well as the gas stations, businesses that are open to the general public. But we also include schools, hospitals, clinics, and we have case law in the state of Vermont that says places of public accommodations also extends to all government entities. And so that brings in some inmate cases at the Department of Corrections, that brings in police cases, that brings in cases where people apply for public benefits and are denied. They could also come because of they believe discrimination, they could also come to the Human Rights Commission as well. We are made up of, I should also mention that some of the more recent legislative bills that have passed have also put various things under the umbrella of the Human Rights Commission, like the flexible working condition laws that were passed. Well, that was passed a few years ago, which has been very interesting during COVID. That also can fall under the Human Rights Commission if the employer, again, is a state agency or department. Anybody that experiences retaliation for taking workers' compensation or parental leave could also come to the Human Rights Commission too if they work for a state agency or a department. So we're made up of 5 commissioners who are appointed by the governor and confirmed by the Senate. And then their role is primarily to hire the executive director and hear the cases on a monthly basis. So once a month, the cases that we've investigated, if we are unable to resolve it, goes to the commissioners to be heard. The parties show up and the commissioners make a final determination that either discrimination has occurred or has not occurred. And that's their primary role. The commission is made up of 6 staff, including myself, a director of policy, education, outreach that you may see at the State House from time to time, Amanda Garces, as well as 3 staff attorney investigators who investigate all the cases across those anti-discrimination laws that I mentioned earlier. And then we have 1 executive staff assistant. We do not have a full-time litigator. The role of the litigator is embedded in part in my job as the executive director, amongst a bunch of other hats that I also have to wear. And I just wanted to talk a little bit about some of the cases that we've done. So we had a case a few years back involving a gentleman who had dementia, who had been approached by a police officer. He spat at the police officer. He went to court. It was pretty clear that he had a psychiatric disability. There was no room at the hospitals for him to go wait for a psychiatric evaluation. So we ended up in corrections. And because of his dementia and the symptoms of that, he obviously behaved in a way that corrections considered it inappropriate. They punished him and segregated him for like 14 days. He filed a complaint of disability discrimination. We found discrimination had occurred in that case, and we filed a lawsuit. Unfortunately, that man passed away during that lawsuit. We have another case involving a woman who was deaf and in need of an ASL interpreter, who went to the hospital and believed that she was having a heart attack. And for the 3 days that she was there, she was unable to meaningfully participate in her own healthcare because she was never provided an ASL interpreter for that whole time. That we also find that disability discrimination had occurred. There was another case involving a woman who was Black, who worked for a state department, and she was subjected to hearing the N-word and other racial epithets on a regular basis for a very long period of time. She had complained about it several times, but her employers had done very little to address the issue. She filed a complaint of racial discrimination. We also found that she was subjected to a hostile work environment on the basis of race, and that case ended up resolving itself. So these are some of the cases that have come before the Human Rights Commission. So yeah, I am really proud of the work that we do. In addition to enforcing the anti-discrimination laws, part of our mandate is also to do education outreach. I've done some for the legislature, but we do them for schools. We do them for any kind of community member or organization that reaches out to us. And the other part of our role is to advance policies, provide support, testify before the legislature, serve on task force and committees, and so forth. And we do a fair amount of that also. So I'm happy to answer any questions. And I would also love to talk to you a little bit about some of our legislative priorities this year, if you have the time.
Yeah, we do have time this afternoon, and I would like to know if there are legislative priorities that specifically touch on, our areas of public safety administration and the structure and administration. So there's definitely overlapping jurisdictions, and I know that you end up having to testify and weigh in on several committees. But before we go to legislative priorities, I just wanted to see if anybody on the committee had any questions about the structure or the role of the Human Rights Commission generally at a high level. You have an excellent website if anybody wants to see the bios of the commissioners and that kind of thing. Those are all available on the Vermont Human Rights Commission website. Does anybody have any questions? Representative Rowick.
Thank you for coming and sharing with us today. I don't know if you can comment any more on this, but you mentioned a case where I think you said it was resolved on its own. Can you explain that to us a little bit more?
Yeah, so part of our mandate is to help the parties conciliate and settle. So throughout the investigation, we will shuffle offers and counter offers back and forth. And many, in fact, I would say a high percentage of our cases actually resolve through that process. In addition to that, we can provide a little bit of money towards mediation if the parties want to attempt mediation without going through the Human Rights Commission as well. And so many cases do settle in that way. They settle during the investigation, and it's also often the case that cases are settling between when the report is finalized and issued and when the commission meeting is scheduled to hear the case. And that's because we have finished the investigation, the parties know which way it's going, they don't want to risk it in front of the commissioners, and then they will also attempt mediation or also attempt to settle at that point too. And so even when we go to a commission meeting and the commissioners find discrimination has occurred, the case by statute comes back to my desk for a 6-month period to try to settle again before we consider litigation. And so trying to help the parties settle is really important for giving people something that you can't get in court. When you're litigating, one, it's time consuming and so forth, but usually people are seeking out a monetary damage relief when they're doing that. And oftentimes we find that people need to maintain their housing. People want to maintain their employment. People just want to improve their workplaces. And so we know that, and we're trying to settle that. When kids come to the Human Rights Commission, let's say they're in the 7th grade, These investigations can take a really long time. By the time an investigation is complete, they might be at the end of their 8th grade year. And so we're working hard to say, how do we improve processes while this kid is still in the school for this period of time? Even if we haven't made a determination that the school did anything wrong, there's absolutely nothing wrong with trying to help the parties get to a place of an agreement about how to improve the process and the system and the environment for the student and the school.
Thank you.
Yeah.
Any other questions before we move on? Great. Well, we'd love to hear about legislative priorities you have this session.
Yeah. Well, I do want to respond to your question around maybe any thoughts related to your committee. And I'm not necessarily prepared to make any recommendations or suggestions, but since becoming the executive director in 2018, I have been thinking a long time about how to make the Human Rights Commission truly independent. And what would that look like and what would that mean? And so it's just something that I want to be thinking about some more, maybe with you all too in the future. Because right now, while we were created by the legislature, we are a commission that falls under the governor with our budget determined by the governor. And also we're a state agency, and who represents us in a lawsuit? Who do we represent? There's a lot of those questions are really interesting. And also building trust with the community if you are not seen or perceived as being truly independent from the governor's office or the attorney general's office. And so these are just things that when there's time, and there rarely is, that I've been thinking about. And I think it would be interesting to brainstorm a little bit. But right now, I think our legislative priorities this year are to advance a few bills that I think are really important. The first one is called the Don't Darken My Door bill. And this is a bill that has been around a few times. In 2000 and I think I want to say 19 or 2020, I forget when COVID started, it had passed in the Senate and it went to the House and it died in committee because of COVID. That's when COVID first started and a decision was made that we were only going to work on COVID related bills. And that's why it died there. Then the next legislative session, it was picked up and passed in the House. It went into the Senate last year and it got out of committee and went to a second reading. And then the Senate adjourned before it passed. So I would love to see this bill pass. And what this is it is a law that would prohibit employers from punishing employees who bring forth claims of discrimination by including clauses in settlement agreements that says they will never be rehired. Okay. The idea is that employers have been using clauses to not rehire employees as a negotiation tool. And when employers are as large as the state of Vermont, when we say that because you were negotiating a settlement agreement with you, you can never be rehired at the state of Vermont. That's essentially excluding this person from ever being rehired across all state agencies and all state departments. That's a very big deal. Even when you're talking about less than like a large employer like the state of Vermont, excluding somebody may mean that they have to leave the state of Vermont because there is no other employer that specializes in that particular area. In 2018, as part of the Me Too movement, this legislature passed similar language as to sexual harassment. So when women bring forth cases of sexual harassment, employers are already prohibited from including those clauses in settlement agreements. And there's no reason why we should treat women who experience sexual harassment in the workplace differently than people of color, people with disabilities, and LGBTQIA members of our community differently than women who experience sexual harassment. And I would love to see that bill passed this year. The another bill is the amending our equal pay laws to include other protected classes, particularly on the basis of race, national origin, and disability. Right now, our equal pay laws only protect on the basis of sex. That means that a woman, typically, who is paid less than her male counterpart can bring an equal pay claim if she finds that her male counterpart, who has the same title or same job role and responsibility, is being paid more. She can bring an equal pay claim. But if a woman of color, who we know with data and statistics is paid significantly less than any other counterpart, if a woman of color is able to point to a white woman in the workplace who makes more than her, even though they have the same job, role, and responsibilities, she does not have an equal pay claim. And that seems fundamentally unfair, that our equal pay laws do not extend beyond sex. The reason why equal pay claims are important, because you don't have to prove under an equal pay claim that your employer intentionally discriminated. So when a woman says that my male colleague is being paid a lot more than me and we're doing the same job, she just has to show that they're doing the same job and he's paid more. She doesn't have to show that her employer paid her less because of intentional sex discrimination. And that's an important claim for people of color and people with disabilities to be able to have in the state of Vermont. And then the last priority bill. And by the way, I want to stop and take a breath and see if you have any questions for me, because those were two pretty big ones that I kind of just talked about.
I don't know that either of those will come here.
No, but they will come to you on the floor one way or another. Yes. Yes.
I'm always rooting, since we have 3 new members on our committee to the legislature, and 8 folks who were not previously on the government operations committee, but we do have 2 members who you would have seen on House General. So yes. I'm always cognizant of kind of sort of level setting expectations and having people understand where things are as we're taking testimony about our legislative agenda and potential priorities. Yeah, Representative Chase.
With regards to the pay equality thing, how would that play with everybody's pay being private, like pay rate transparency?
Yeah, so there are some bills to try to create more pay transparency. There obviously is pay transparency at the state of Vermont, but it goes along with pay transparency and the ability to know what other people are getting paid. But even without pay transparency, you can still find out just through conversations at work that your coworker is making more or less than you. And we've had cases at the Human Rights Commission where women have come forth and said, I don't understand why my male colleague is making significantly more than me when we're doing the same job. And in fact, I'm doing a way better job, or I might be supervising even more people, or I'm doing this and so forth. And so they do find out, even without a law in place around pay transparency, around what people make. And it's a sort of, and their male counterparts are also supportive of them getting equal pay as well. And so we often find that it's not even contentious between the colleagues. This is a matter of a business decision that employers often make in terms of who they pay and how much and why. And there's a lot that goes into why an employer might pay somebody something. But the idea is that in a world that is equal, when people are doing the same work, they should be compensated the same. And that there's no reason why women are treated differently under our equal pay laws than people of color or people with disabilities or LGBTQIA community. So in both of those laws that I mentioned, it's not that women face discrimination more often than any other group. In fact, there's absolutely no basis to believe that. And so the question for us is, if we can pass a law in 2018 that protects women from never being rehired when she brings forth a sex harassment claim, why don't we do that for people of color? And why don't we do that for people with disabilities as well? And the same is true. If we've passed this law under equal pay for a very long time and we've had this in place, why aren't we extending that to the other groups of people that we know are paid traditionally less than their counterparts in the workplace? And I share this in every committee that has invited me to come in and do an introduction, because I do know at some point, hopefully, that it will be on the floor and you will be voting on it. And it's important for you to have heard about it at least once before. And they are so important. And your role as that vote is so important too. So I just don't want to take that for granted.
Thank you.
Okay.
So much. Yeah. So are any other questions on
those two?
Okay, great.
Yeah, so our third priority bill is a bit more controversial, and it is a bill to change the way that our courts have looked at severe or pervasive as a legal standard for harassment cases. Currently, the legal standard for how courts view harassment across housing and not housing, and I'll explain that for a second, but across employment and places of public accommodations like schools, is that we apply what's called a severe or pervasive standard. The harassment must be so severe or it must be so pervasive in order for it to be actionable or cognizable in court. And the severe pervasive legal standard came about because of a 1986 case that went to the US Supreme Court involving a woman who had been raped multiple times by a supervisor and stalked and harassed. And the court said, it's like harassment has to be a form of discrimination. We've got to open the door. And in order for us to find the harassment is serious enough to sue, it has to be severe or pervasive. Now, that was a case that was clearly both severe or pervasive. But since that decision was made, you've had courts all over the country interpreting severe or pervasive inconsistently. One, the US Supreme Court never defined what had to be sufficient to be severe, and they never defined how often something had to happen to be pervasive. And so you've got decisions all over the country that have said, well, stalking by a supervisor is bad, but it only happened a couple times. It's not severe. Or a supervisor who touches a woman in her private places, well, that only happened once, so that's not severe. Or, making comments about a woman's body in the workplace over 3 or 4 months, yeah, it's uncomfortable, but it's not pervasive, right? And so what we have is a legal standard that has been used and does not reflect what our values and our morals and our principles are about what's appropriate behavior in the workplace. The problem with these legal standards is that, one, we have to follow them. And so once a court has decided that these set of facts do not meet that legal standard, it also means that other cases may not be able to be brought in court. But it also means that we train to the legal standard. That means that when we're doing sexual harassment trainings, we're always saying what is severe or pervasive. And we're not training on best practices, or we're not training on stopping harassment before it gets to that place, because we're training around compliance and compliance with the law. So it's time that we revisit severe or pervasive as a legal standard for how we view harassment in the workplace. In fact, Vermont courts even got it wrong once when they said it has to be severe and pervasive. And that was just incorrect. And then the legislature had to go back the next year and fix that when the Vermont courts interpreted that legal standard incorrectly. And so last year, that standard was corrected in housing. And that allowed one case at the Human Rights Commission to get to reasonable grounds determination. We had a case in housing where a landlord had called somebody, had called this person a welfare bum a couple of times because they were receiving public assistance. The same landlord made some sexist comments, and the landlord also made some comments regarding their psychiatric disability. Now, under the old severe pervasive standard, the courts would look at each of those things and find that being called a welfare bum once or twice is just not enough for public assistance discrimination. It's not enough for severe or pervasive. The sexist comments that were heard a few times, not enough. And the psychiatric disability comments that were made, not enough. But we have the same landlord, we have the same tenant. When you look at the totality of circumstances, under our new corrected standard in housing that was passed last year, that case was able to reach a reasonable grounds determination that discrimination had occurred across all of those protected categories. Okay, we're looking at the totality of the circumstances and making a decision whether or not this person had experienced a hostile housing environment. And that's what we are hoping to do when we correct the legal standard in our workplaces, as well as our schools and other places of public accommodations. So I'm happy to take any questions that you have.
So I think our colleagues, perhaps in judiciary, will have the jurisdiction over contemplating those legal standards, but we'll have had a good preview for if and when that hits the floor.
Yeah.
Are there any questions? Yeah, Representative Murwicki.
Perhaps you mentioned this already, but do you have a bill or language queued up for this?
I do. The first bill, the Don't Darken My Door bill, and the last one, the severe pervasive stuff, those were already introduced last year, and I imagine the same language will be picked up this year. I don't have a current bill number attached to it yet. I know that there's going to be a Senate omnibus bill that will be picking up all three. And then the equal pay bill, I know that there's been representatives and both Senate members that are interested in picking that up, but I don't have a bill number yet. I also just wanted to share that my other role is really just education and outreach and support. So if you ever find as a committee that maybe you have questions or you're in need of how to make your committee more accessible or more equitable to the people that appear before you, I also do committee specific trainings, or I'm happy to answer any of your questions as well. So don't hesitate to reach out to me individually or as a committee. I'm here for you.
Thank you. One of the things that I would love to have your input on when we take it back up is that we went very quickly to extend the open meeting law, remote meeting without a physical location. And one of the key issues that will come up as we look to the future and try to develop best practices for having those meetings that are subject to the open meeting law be allowed to do both hybrid and fully remote meetings for indefinitely into the future are issues around equity and accessibility. And I would really appreciate, if the Human Rights Commission, if your commissioners, if you and your staff would be willing to give us feedback about some of the current practice and what we could do better to make sure that Vermonters have real access to democracy.
Absolutely. Yeah. We've been struggling and challenged by that as well at the Human Rights Commission, because our commission meetings are also subject to the open meeting laws, and returning to having a physical presence and ensuring that people have access to our meetings has been really interesting. And we've also been talking about when one party shows up virtually, but another person shows up in person, is that equal treatment, right? Are we treating people equally as well? When there are technical difficulties and we're having difficulty hearing somebody because of technology, does that interfere with our ability to make a fair decision in those cases as well? What happens when people show up and our commissioners are appearing remotely? Does that feel fair to the parties that show up before? And so, yes, I would love to engage in that conversation at some point, because it's something we're always thinking and talking about also.
Our counterparts in Senate government operations, we have very loudly committed that we are going to dive into that conversation this year. So we'll definitely have you back for that.
Perfect. Great.
Are there any other questions for Executive Director Yang before we depart? Great. Well,
we're going to see her on Friday, right, for the ethics training, is that?
Yes, and you're going to be here for the ethics training, I believe, maybe? No?
I don't think so.
She does a great job.
Yeah, I believe.
Thank you, but no, I don't think that's me. I hope not.
Never mind, sorry.
We haven't been part of great trainings with you in the past. I think Representative Hooper's just a big fan.
Yes, thank you. Thank you for saying, yeah.
Yes.
So I think that that's it, unless I see any other hands from the committee. I really appreciate you coming and doing an intro on short notice and taking up some of our introduction walkthroughs. And I look forward to working with you over the course of this biennium.
Me too. Thank you so much. Thank you all for your time. Take care.
Great. Well, we breezed through our afternoon agenda, so we've got about an hour to work on bills and do committee time before floor. So I will see you all upstairs at 3 o'clock. We will be starting tomorrow at 9:30 in committee.
30.
So I pushed it to 9:30 instead of 9, just because people like me might have travel unless. The snow and the ice may be a little rough, hopefully not too bad, but be safe out there, and I'll see you floor at 3 and then tomorrow at 9:30 for a little discussion and a presentation about how elections work in Vermont to prepare us for our work on some elections legislation that's coming up.
So.